This is the Insurance versus History podcast, and I am Meredith Brasher, researcher, writer, editor, historian, and former insurance professional. I am obsessed with insurance history and with explaining how insurance works and why it matters. This is the second episode of Season 5, and it's a little different than what I've done in the past. I'm experimenting with a lot of things this season: format, topics, sound design. One of my goals for this season is to stay a little inventive. I'm an independent podcaster, and I plan to stay that way, so this is one of the perks, I guess. If you love it or hate it, I would love to hear from you. But again, be nice. We could use a little more nice in the world, even when giving constructive criticism. If you are feeling nice, well, you could also do me a favor and rate and review the podcast on your podcast player. It helps other people discover the pod, and it only takes a second. And make sure you subscribe to the pod. And you can also hire me to come talk to your organization or meeting about insurance history and why insurance matters. Today, I am doing a shorter episode, and I wanted to pull a current news story and put it into insurance and historical perspective. And one story that jumped out at me this week was the FTC's statement that they would no longer enact their 2024 rule banning non-compete agreements. This wasn't really a surprise given the current administration, but did you know that non-compete agreements go back in history to the 15th century? I did not know that until I started researching this topic. The change in the FTC's position on non-compete agreements affects all Americans who work in the insurance industry and outside the insurance industry. Now, for insurance professionals, especially people on the agent and broker side, non-compete agreements are very common, and changing jobs can get messy. This is a fight about who you can work for and what you can do with the knowledge you have as a professional, and I think it's important to talk about it a little, especially for people who may not understand how non-competes work. There's not a ton of insurance lingo that you need to know for this episode, but I should touch upon the fact that there are a couple of insurance products that cover lawsuits related to non-compete agreements. Unfortunately, they don't usually cover employees who violate non-compete agreements. I put violate in imaginary quotes because I'm actually not a fan of these agreements at all, but the insurance could cover a company who was sued as a result of a non-compete situation. Most of these insurance products fall under something called management liability insurance. This term is an umbrella term that covers a handful of different insurance products, including employment practices liability or EPL insurance, directors and officers or D&O insurance, which I talked about in my Enron episode, fiduciary liability insurance, and kidnap and ransom insurance. Fiduciary liability and KNR, which is how we usually refer to kidnap and ransom, those two types of insurance don't really come into play when it comes to non-compete lawsuits. It's mostly just D&O and employment practices liability. D&O gets involved if someone, generally shareholders, if someone sues the directors and officers of a company regarding illegal or punitive non-compete agreements, and EPL would get involved if there was a lawsuit against the company if someone alleges that the non-compete violated their rights as an employee of that company. Got it? Good. Let's talk about this story. Last week, the FTC said they would no longer enforce a rule established in 2024 under the Biden administration that would have made non-compete agreements mostly unenforceable. If you're not quite sure what a non-compete means, well, it basically is an agreement or contract you sign as an employee stating you will not work for a competing organization in the same field for a certain period of time after leaving your current employer. In the insurance industry, that length of time is usually 18 months or 2 years, or at least that's what I remember. Someone will correct me if I'm wrong, I'm sure. In theory, these non-compete agreements are supposed to keep employees from leaving and taking proprietary information with them. This is different than a non-solicitation agreement, which bars you from changing employers or starting your own firm and then bringing clients from your old employer to your new one. Non-solicitation agreements are very common on the agent and broker side of insurance, which makes sense because these are the salespeople of the insurance industry who often build close personal relationships with customers. I am unaware of a non-solicitation agreement situation on the insurance carrier side, and frankly, there have been multiple situations in my career when I was expected to bring over a big account in some form, though maybe not in the same insurance layer from my prior employer. Non-compete agreements have come under a lot of scrutiny in the past 20 years, and especially as respects low-wage workers. You might recall there was a story in 2014 about how Jimmy John's, which is a U.S. fast food sandwich restaurant, how they were requiring employees to sign non-competes to work there. Now, these weren't corporate employees or executives. Well, maybe they were as well, but it was specifically the people who were working in the stores making sandwiches for people. This was a great case to bring as an example because it made it very scary legally for these workers to change jobs to work at, say, a Subway store, which is another American sandwich chain. And frankly, these non-competes made no sense. I mean, there really isn't anything special about making a sandwich. I mean, it is true, Jimmy John's has fewer sandwich toppings than most chains, but I'm not sure I'd call that a trade secret. The whole thing was, well, kind of boneheaded. But over the past 20 years, these types of things were starting to pop up with American employers, and not surprisingly, a lot of people thought they were unfair. I should add for our British listeners that the non-compete did not also provide garden leave, which is a kind of leave that they have in the UK, where your company pays for you not to have a job. That's not what's happening here. You get no consideration for signing the non-compete. You might get sued, though, if you take a job and start violating that non-compete. Historically, though, non-compete agreement issues go way back. The first mention of non-compete agreements in English law is in 1414, believe it or not. This was a case where John Dyer, an apprentice, entered into an agreement with the tradesman he worked for that once he went off on his own, he would not work in the same geographic area for 6 months. Now, why either of these people entered into this agreement is interesting and unknown. But not surprisingly, John started working within 6 months in the area around his original employer. This isn't really a surprise. This isn't a time period when regular working class people moved around or had a lot of mobility. The tradesman sued his former apprentice, and the English courts basically shot him down, saying that the agreement was against the common good. And the judge also added, "By God, if the plaintiff were here, he should go to prison until he had paid a fine to the king." The tradesman wisely did not attend the trial. Non-compete agreements were officially unenforceable under English common law at that point. Then, in 1621, the courts changed their mind in a case called Broad versus Jolliffe. We don't have a lot of information about this case, but basically it allowed a non-compete as long as it was very limited in scope and geography. In 1711, a few years before friend of the pod, Lord Mansfield would become Chief Justice of the King's Bench in England, the Chief Justice at the time, Lord Macclesfield, held in a case called Mitchell and Reynolds that if the non-compete was limited in time and place, it could be enforceable. In the same case, he also said that a contract that attempted to restrain trade generally was not enforceable. This case is the basis of all modern antitrust law in the U.S. You're welcome. In the U.S., decisions about non-competes have generally been left to the states, and most states do allow non-compete agreements. 3 states, California, North Dakota, and Oklahoma, banned non-competes in the late 19th century, a few years after the Civil War, and even before Oklahoma and North Dakota were officially states. In the past 20 years, a number of states have tweaked their non-compete rules, with many of them starting to eliminate non-competes for low-wage workers, especially after the whole Jimmy John's debacle in 2014. I personally cannot see any reason for a non-compete on a low-wage worker, except as a punitive measure. Can you? The changes to eliminate these types of non-competes for low-wage workers, those have been bipartisan as a rule. On the federal level, several Republicans, including Marco Rubio, and Democrats have tried to pass bills restricting the use of non-competes. These bills usually had exceptions for higher-earning executives and agreements surrounding the sale of a business, both fairly reasonable exceptions, in my opinion. It was part of President Biden's platform in 2020 to try and eliminate non-competes as much as possible. And that's how we got to the FTC rule in 2024. This new rule had a few exceptions, including exceptions for contracts involving the sale of a business and for what they called senior executives, or anyone earning over $151,000 a year. The insurance people listening just perked up their ears about that last part because, based on that, there are a whole lot of people who don't have a senior executive title who would have been exempted from the FTC ban in the insurance industry. I don't know where they got that salary number from, but that's just kind of nonsensical, in my opinion. This rule was, of course, challenged in the courts. And then the change in administration meant it was likely to be halted, which it was, one day before it was supposed to take official effect in 2025. Though again, I would like to stress that the bills put forward in Congress to legislate this on a federal level to restrict the use of non-competes were all bipartisan affairs. From an insurance standpoint, of course, there was a lot of concern about what would happen in terms of potential claims when the FTC rule would have gone into effect. What had been legal, non-compete agreements, would then have been illegal. And while illegal things are generally not covered by insurance, management liability insurance products would have kicked in to pay defense and, in some cases, could pay damages. For insurance professionals specifically, well, as I said, non-competes are not uncommon in our industry. The U.S. Government Accountability Office report in 2022 said that almost 50% of companies in finance and insurance have some kind of non-compete in place. I couldn't find any specific numbers just for insurance, but I suspect it's probably in the 30% range for insurance companies and much higher for agents and brokers. Just looking at the Insurance Journal website, I found a bunch of stories about lawsuits involving non-competes in 2025. It's definitely a thing. Now, non-solicitation agreements, these are the ones where agents and brokers are barred from taking clients with them for a certain period of time. These are the ones the industry hears about the most, and frankly, my experience has been that when an agent or broker changes jobs, the new employer just accepts that they're probably going to have to pony up some legal fees to protect their new employee. These were not considered as part of the FTC non-compete ban, just FYI. I was never asked to sign a non-compete, although I did sign an NDA at one company. However, it's becoming more common to sue when underwriters move too, especially in situations where more than one person from a team at Company X moves to Company Y. It depends on how mad the insurance company gets. If you want a good example, you can ask someone in the industry about the Gen Re lawsuit against Arch Insurance in 2007. I mention that one specifically only because I actually worked at one of the companies when it happened, and I sat next to some of the people involved. It was messy. While I do understand the need for non-solicitation agreements, I'm not sold on them, as I think they have the same issue as non-competes. And I think that non-competes should probably be a thing of the past on all levels. If the argument is that an employee should not be able to take their insurance training and knowledge to another company, well, I would take issue with that in almost all circumstances. There are two issues here. First, Is the knowledge really proprietary? As much as insurance companies, public adjusters, and agents would like you to believe that they are special and that what they do and how they do it is unique, after 20 years of working at various insurance companies, I am here to say that I have yet to see anything that was a true trade secret. What I did at one company and how I did it was not very different from a different company. And even rating information and underwriting guidelines, which a lot of companies think are very unique and special, they're often pretty similar. And the other thing is underwriters talk. And I imagine it's the same with other parts of the business. I know a lot of things about accounts I never worked on, some of which might have been considered a trade secret. But everyone in the market knew about them, especially in insurance. What an employer is paying us for is our experience and knowledge. And taking that away is punitive and unfair, which leads me to my next point. I'm putting this on companies to do a better job of retention and hiring. You know what keeps people at a company? Good working conditions, training, and appropriate salary increases. It's long been a running joke that the only way to get a decent raise in insurance is to change jobs. And that's true. You might see that 3% cost of living increase at your current job if you're lucky, but changing jobs could get you a 20% increase, even without a job title change. And how much did it cost your old company to then replace you? Was it just so awful to provide higher raises, say every 5 years, and keep people happy and keep that institutional knowledge in-house? Insurance is a field where the experience of the people on the front lines is invaluable, and it cannot be replaced by a machine. You can take classes, you can get a risk management degree, but it really does not prepare you for the day-to-day life of working in insurance, especially in underwriting, claims, and frankly, the broker and agent side. How do I know what hidden things to look for on a particular type of risk or the pitfalls of a particular type of business? How do I know who to trust and who to trust but verify? From experience, from coworkers, and frankly, from the stuff you screwed up in the past. Do better, insurance executives. You don't need all these punitive measures like non-competes and non-solicitation agreements to keep people if you provide things that make people want to stay on their own. And maybe that's the lesson here. Maybe if I got through to one insurance executive that listens or someone who will become an executive one day today, then it was all worth it. In the end, it seems that the FTC rule is gone, and we're back to a hodgepodge collection of state rules about non-competes. I suspect it will stay that way for a while, and we'll all just have to adjust. Just be careful when you sign a non-compete or non-solicitation agreement at your new employer. Make sure you know what you're getting into. Thanks for listening. I hope you learned something. If you liked the episode, again, please rate and review on your podcast player of choice. I love to hear from listeners. You can reach out to me on LinkedIn or email me at meredith@insurancevshistory.com. My next episode is one that I've been thinking about for a while, and not just because I had the risk come across my desk several times in my underwriting career. The Boy Scouts of America. I hope you'll join me. And of course, be safe, be smart, and read your policy wording. And by good working conditions, I don't mean an espresso machine and the occasional jeans on Fridays, guys. You know what I mean. We all know what I mean.